Commence with the first session of today's workshop in 1 minute. Let us now proceed with the first session for today's workshop, which is based on the theme Copyright in the Age of Remake and Adaptations. It gives me immense pleasure to introduce you all to our panel for today's session. Advocate Gowree Gokhale, practicing lawyer at TMT Nishith Desai Advocates. We also have the pleasure of having Dr. Birendra Saraf, Senior Counsel, practicing at the Bombay High Court. Next, we have on the panel Mr. Anil Lale, General Counsel, Viacom, 18, who is a lawyer by profession and a postgraduate in media laws from National Academy of Legal Studies and Research. And last but not the least, Mrs. Pooja Kapadia, Head of Business and Legal Affairs, Tulsea Media Pvt.Ltd. On this note, without further ado, I now hand over the podium to Advocate Gowree Gokhale to lead the discussion forward and engage with our esteemed resource persons on the panel. Over to you, ma'am.
May I have now the panel on the stage, please? Thank you, first of all, agreeing to join the panel just with one message. We really appreciate your time. Since Dr. Saraf, has some engagement, he needs to leave by 12:30. So what I'm going to do is first let's just do a little warm up on some of the key basic issues, and then I'm going to request Dr. Saraf to give his exposition on the theme. I think the one of the important aspects that we often encounter when we do any deals or we are engaging into any litigation is the identification of the ownership. I think in the earlier discussion there was a question as to what happens as who is the owner in relation, or who is the author in relation to the computer generated work. Interestingly, our Copyright Act already answers that in 2D of the Copyright Act, so whoever is interested can quickly look at that. But my first question to the panel members, and Dr. Saraf and Anil, to you first, is when you are looking at any transaction or litigation in terms of identification of the work, unlike the US where most people go register copyright, and in India it's not compulsory, but in US you do have benefit of treble damages if you register copyright, right? So in India there is no such incentive. And then we have Screenwriters Association, which is more of a practical aspect where people go register. So what are your takeaways as to whether we should develop some mechanism? And just to give you a quick background, in one of the conversations which sir also had attended, Justice Pratibha Singh in fact had recommended that should we in India create some kind of a registry to identify the ownership. So your thoughts on what are the current issues being faced and what are the takeaways from you? First, Dr. Saraf, if you want to quickly address that.
Gowree, you're absolutely right that India does require a kind of a registry to register the copyright of various people involved in particularly the entertainment industry. It starts with maybe a story, a script, a story particularly. And as Gowree said, as of now, we at the highest have a very, very fluid situation of a person going and registering his story or script with the Screenwriters Association. But most often than not, what happens is there is a complete lack of awareness as to what is the copyright and in whom it vests. And there is no means of finding that out except for that one public notice which we issue in a trade magazine, to which most of the people answer is that I didn't notice it. And particularly if you come down to script writers, etc., they don't sit and read public notices everywhere. We had a very interesting case where in one of the matters, a lady who was the producer of a film went about creating multiple agreements in favor of different parties. So whenever she would need money, she would go and execute an assignment agreement giving satellite right to someone. 10 days later, she would execute another agreement for the satellite rights in favor of someone else. And how does the second person know that she's already created these rights in favor of someone? So it's extremely important that we have a very organized system of registration, which will also maintain confidentiality, because particularly if we talk of a script, a story, the registration thereof should have a great deal of confidentiality involved, because that should not be accessible to the public. So, and the difficulty also comes from a situation that a story is a very fluid thing at times. He may have named it something else. So how do you identify and find out as to whether that same story is registered or not? But particularly once a film has come into existence, then it can be much more crystallized. Who holds the satellite rights? Who holds the OTT rights? Who holds the theatrical rights? Each of those aspects should be available on a platform at a click of a button, where people, before entering into an agreement, can see that this is the right already created. And that is a great requirement in the entertainment industry today, because most of the litigation which emanates is from multiple agreements. It reminds me of the old time, where registration of documents used to take 8 years, 10 years, and in the meanwhile people used to rampantly create rights. Now today the situation is this, that once a document is registered in respect of an immovable property, in the evening it is uploaded on the website. We should surely arrive at such a situation. So far as commercial understandings are concerned, there could be easily a methodology of redacting that, so that people's commercial understanding, the money which they are paying for a particular rights, etc., are not disclosed to the competitors. So they can have so many ways of protecting that, but that is surely a very urgent and emergent need in India to protect copyright.
Anil, your take.
Yeah. Sorry. So I completely identify with what Dr. Saraf just mentioned. A lot of disputes arise from rights being, there are double sale of rights that happens, and all those issues that comes into litigation. Regarding the registration of rights, yes, when you look at original literary work, musical work and all those things, the registration is comparatively easier because it's an ownership that gets registered. But when we get into the domain of exploitation, I'm talking purely from a practical perspective of handling such rights on a day-to-day basis. What happens is that, let's say, a cinematograph film, it has ownership as a work under Copyright Act. But when it comes into a studio or a broadcaster or an OTT platform like ours, what happens is that this gets bifurcated, or there are a lot of strands that emanates from one particular cinematograph film, which is capable of exploitation through various platforms. Let me give you an example. Satellite rights. When you talk about satellite rights, it's one part of a whole genus called linear rights. So when you have a cinematograph film, it can be transmitted through satellite, it can be transmitted through cable, it can go on OTT platform, it can go through an IPTV platform. So each of this becomes different various rights. Similarly, on demand, when you take the same cinematograph film and put as on demand is a common term used for when you demand and when you get it. But the commercial model of exploitation of that also includes SVOD, which is subscription video on demand, AVOD, which is advertisement video on demand, TVOD, which is transactional video on demand. These are all different rights again. So, and these rights keep on, changing hands. As in, as let's say Viacom 18 Motion Picture Studio, we engage a production house to produce a movie. The first owner as a producer may be or we acquire a movie, so the producer may be the first owner. Then all the rights or some of the rights gets transferred to us. Then we sell SVOD rights to, let's say, Netflix. Then we sell TVOD rights maybe to an Apple. So this is a very it's a day-to-day business scenario here we are talking about. So we have an internal RMS system, which is the rights management system, which has around 290 different bifurcation of rights from a single cinematograph film. So a public database, if we are to establish something like this, will it be capable of handling such a complicated rights management? Because when we are talking about registration here, it is going straying slightly away from rights, registration of rights and getting into rights management, because every subsequent owner also has to be registered. So we'll need to think through all these complexities before we implement it as a law, saying that if you have a particular right, it needs to be registered, or it has some issue, it will have some issue with the ownership of that right, because then it affects the day-to-day process of business also. But at the same time, yes, if there is a original literary work, dramatic work, the whole ownership of a cinematographic film per se, to trace the rights to the original owner, there can be a database for that purpose. That obviously would be a great idea.
Right, so I think there have been discussions for, such as use of blockchain and all of that. So maybe that is something the DPIIT cell here can take a note, as both the arguing council as well as the industry feels the need for that, and maybe that is something we can add as our recommendation as well. I think the next point is which I'm going to request Dr. Saraf first to give your perspective on when we always say idea versus expression dichotomy, and then when we talk about inspiration, when we talk about incidental use, as also the concepts of remake, because none of these are defined in the Copyright Act, right? All these are contractual based. When you say derivative work, that is not defined. It's an adaptation that is defined, but in a different context. We also have concepts of franchise now being developed. When you have you saw the Singham franchise, right? Then you have spin-offs. So many new concepts are coming up. So Dr. Saraf, first over to you. When we talk about the first aspect is inspiration, incidental use, and then look at section 52, whether that adequately addresses, or how do we look at that, whether there is infringement, no infringement, what are the case laws saying? And secondly, on remakes, etc., how has the case law evolved outside the Copyright Act, and whether you believe that that is a good way to handle the situation, right, rather than making amendments to the Copyright Act to bring these concepts. So if you can give your perspective on these, and then I'll move on to Anil and Pooja.
So basically, they say imitation is the best form of flattery, but may not be so true so far as the entertainment industry and copyright rights go. So we faced a very developing kind of regime in India, and according to me, the Copyright Act, so far as cinematographic films are concerned, has a lot of lacunas which need to be redressed. It's interesting because though adaptation is defined in the Act, and if you take literary work, it speaks of an adaptation into a dramatic work, cinematographic film, etc. But if you take section 14 and consider the copyright in a film, it doesn't talk of an adaptation at all. It doesn't give an exclusive right to an owner to adapt. So why is that so? Because maybe that was not a situation which arose at a given time. So 14, I find, requires, so far as cinematographic film is concerned, surely a much wider protection, a wider network. And it is this lacuna in the language of section 14 which led to a rather odd judgment of the Bombay High Court in the case of Leo Brunet, which said that a copyright in a film is infringed only if a physical copy is made of the film or something like that. Now that judgment was governing the field for a long time. It is recently that a full bench of the Delhi High Court in an MRF judgment ended up saying that no, that's not a correct exposition of law, because when it uses the word copy, it doesn't mean a physical copy all the time. A copy has a wider connotation in light of the Berne Convention, etc. So we need to, I feel, have a situation whereby the copyright in a cinematographic film is expanded, but it should not be expanded in a manner which is too well defined, because as much as human originality knows no bound, the ability of a human being to copy also knows no bounds. So we must keep that definition wide enough so that ultimately it is a perception of a court which can fall in one of the categories. Because ultimately, what is an adaptation? The origin of adaptation has been very late in the Copyright Acts all over the world earlier. Adaptation or derivative rights were not protected at all. In fact, in cases of books also, even translations were not protected. They said that owner doesn't have an exclusive right to translate the books. It is much later in the 1900s that the statutes amended to bring about a copyright in the Derivative Act. But so far as films are concerned, as you all know, the locus classicus in India is that R.G. Anand judgment, which says what is effectively a copy of a film or an adaptation of a drama or theatre into a film. It said that if ultimately a man sitting there in the theatre or a film thinks that I've seen this somewhere and recollects it, central theme of which he feels, it leaves him with an impression that this is copied. So you have to ultimately take the two works as a whole, compare them as a whole, and see what is the copying, what is the extent of copying, what is the central theme, is the expression copied. Now that is a task which has to be ultimately left to a court of law. But my experience has been, and that's unfortunate, that we do so many matters relating to maybe infringement of a copyright in a film, but I've rarely come across an occasion where the judge has taken the trouble of watching both the works. Most of the times, the judge just sees two charts. What are the similarities, what are the dissimilarities? But most of the courts say that is the last way to analyze a film. You cannot dissect a film, say these are similar, these are dissimilar. You have to have an overall feel, an overall impression of both the works together. So therefore, the difficulty that our courts are facing, because of course constraints of time, I don't fault them for that, is that the court has no time to see the two works. And if the courts cannot see the two works together, then it's a very difficult decision to arrive at. It's just ultimately the look and feel of what the lawyers present as the film. So the film loses and we create a film in front of the judge, which is not a fair thing. It is the author, the producer, the director's work which should be seen by the judge. Here I create a film in front of the court. And very often I find that original work is laughed at by us lawyers sometimes. I'm more of a producer's lawyer. So very often, we just say, what is there? Isn't it a regular day-to-day life? But everything is day-to-day life. Every original work has some basis in a social framework. As they say, the difference between a film and a book is that when you read a book, you create your own imagination. When you see a film, you are seeing the imagination of a particular person. So, therefore, the difference is in how you have imagined it, how you have expressed it. If the same book is created into a film by 4 different people, which has been done in the past, it could be done in 4 absolutely different ways. And that expression is something which ultimately a judge should appreciate. The character, the way in which the character carries, it will be amazing that in India today, we have so few judgments on a copyright in a character. There is very few judgments, but ultimately today, what was Sholay? Sholay was a dacoit in Chambal. So many films are made in it, but ultimately it was that character of Gabbar Singh which created that film, that expression of that man, of how it will go about the unfolding of the scenes. Now that is where we need to appreciate where an adaptation comes from, where a remake is a very different concept, but adaptation is a very fluid concept. You need to understand whether the heart, the soul and the core of that movie has been copied by someone, something which is so essential to that movie has been copied by someone. And that can be done only by a third party neutral person who steps down, not from his intellectual, expertise of doing a super dissection, but similar to what I would say in a trademark analysis of an average man with an imperfect recollection, of a common cinegoer, what will he think? And that is where ultimately a test of a court lies. But you surely cannot do that without doing an analysis of both the films together. So far as remakes are concerned, there we are facing a rather different and odd kind of a situation. Remake is usually understood largely as almost a scene by scene remake of that film. Recent thing is Drishyam, which has come as a remake. Now, many of the older films of India, you will find virtually a remake of a Western film. But that time the rights were not that asserted. People were not so conscious in asserting rights, and therefore they went by. Nobody bothered. Maybe somebody in Hollywood didn't even know what was a film made in India. But today things have changed. So very often now we find producers also much more conscious in obtaining rights. But what happens from the remade films? Like one of the issues arose in Delhi now, where a person gave a right to remake a film in Malayalam. Now, the film was made in Malayalam, there was no grievance about that. But then, the person who made the film in Malayalam gave a dubbing right of his film into Hindi. Now, the Malayalam film is a different work altogether. It may be a remake of it, but ultimately it's a different work. He is not dubbing the original film, he is dubbing his own film. So, effectively, ultimately to a viewer, this will be something which is a Hindi thing. And that has been ultimately the court in Delhi has held, I think, that it is not a breach of the copyright of the original person, because this is only a dubbing of the Malayalam film, of which film he had a remake right. So these are complexities which to some extent need to be addressed in the law, that what is the derivative work, what is the right in a derivative work of a derivative work. Now, interestingly, Gowree just spoke of Singham, and that's because I think some stage we all have handled a matter relating to Singham and their derivative rights, etc. There is still an ongoing controversy in court whether the derivative right, if a derivative right of Singham 2 has been defined as being a derivative right of Singham, but whether the person has himself a right in Singham 2 itself or not, which was a pre-existing right, these are complex situations, and everything cannot be answered in an act, because how much ever you think, there will be situations which nobody has imagined. Therefore, you need to amend the act, yes, but not make it so watertight that with innovation, with change of situations, we cannot meet those situations. So we must have an act which will meet the needs of the growing times. So this is where there are so many aspects, but these are broad thoughts, and if there is any focused question on this, we could answer it. But anything else, Gowree, which you would like me to touch upon, I'll be happy to do.
I think the other aspect that often comes in the fair use is the parody, right? And because our act, if you see section 52, is not giving sufficient leeway to, for us to take a view. So there are these situations where you are taking inspiration of something, and whether it amounts to a fair use or not. So do you have any thoughts whether our act needs to revisit that aspect?
I really believe that fair use has been defined in a US statute. It's not defined in an Indian statute. Delhi High Court has, in one of the judgments of super cassettes, done a very good analysis of what could be a fair use. And I think that judgment is a very good guiding principle, and somewhere I feel that it is better not to give a very crisp and precise definition to fair use, because ultimately fair means an honest use for a purpose which is not competitive. Broadly it means that which is not trying to commercially exploit the rights of somebody else, the goodwill of somebody else, whatever the reputation of the other film. And so long as that is the essential theme of what we do, I think fair use is something we should be left for a case-to-case basis. We could have a broad parameter in the act. And as I said, the Delhi High Court has done a very brilliant analysis of it. I was thinking of a situation where same use could be a fair use or could not be. And I was thinking that suppose there is a program on YouTube which is in the nature of a training for actors. It's a training course for actors, and they take a subscription charge, and in that they show a film, a clip from a film, and then they do an analysis of that, and they say, just see how this actor has acted in this situation, see how this actor has acted in this situation, what is the difference, what are the analysis of it. It's a way of teaching the students. There could be another channel which says, which takes the best scenes, say it's a comedy film, he takes 5 best scenes from that film, and at the end of every scene, he says, what a brilliant scene. At the end of other scene, he says, hilarious. That is a comment, but his purpose is not to analyze. His purpose is to create a program where he shows the best scenes of that film so that people subscribe to his channel. Now that is not fair use. So therefore you have to keep it from a situation to situation and leave it to be analyzed with the intent, the purpose, and how it is used. As I said, human ingenuity can have no answer. If we define it strictly, we will find 200 ways of getting out of it. And it's good for us, but not good for the industry. So that's where I feel that it should be left a little fluid. We could have broad parameters and guidelines, yes.
Thanks for that excellent example, and sometimes you learn the law with these examples. Since Dr. Saraf needs to leave, if there are any specific questions for him, then we can take those first.
My apologies, actually I had lined up something at around 12:30, quarter to 1.
Film production producers in the advertising sector.
In the?
Advertising sector.
Yes.
So the marketing sector, advertising sector, every day, somebody, I know somebody goes to me, who runs an advertising agency. If I run one or two every week, he gets another ad copy. So, but there's no end result to, they've already advertised content. Rather, it turns out to be a PR activity. I remember last 1 or 2 years ago, there was this ad, Hindustan Times ad on the front page, which basically said, one side there was a picture of Jolly LLB, the other side, there was Suits, the character from Suits. And they said there's some university that I don't want to name, but said that if you appear in our college, then you will be Mike Ross rather than Jolly LLB. And it's a big PR activity after these film producers of Jolly LLB said, you need to apologize. A bad example. But it turned out to be a PR exercise later on for them, for the so-called university, to broadcast this further that this particular actor has gone on. So, what is the defense? What is the defense that the law gives us? Or what are the expected results that a person should have in that case?
Okay, let me tell you, that's a very pertinent question. What you said is, what is the emergent action that needs to be taken and what is the end result? Because very often, as you said, the purpose is served by showing it. That person has gained the publicity. The difficulty lies in India mainly because the litigation takes that long to decide. And everybody knows that damages is an illusion which will take very long. Now, Delhi High Court in recent times has evolved a policy of, instead of going into a crystallization of damages till the end of the suit, they have been kind of granting ad hoc damages. So if we were to reach a situation where damages can be granted very expeditiously, that will be the only deterrent to a copyright infringement. Secondly, our courts, particularly the Bombay High Court, has kind of created a formula that if you come to court delayed on the eve of a release of a film, then you are not entitled to any relief. Now that, in my belief, is a too broad and over-encompassing kind of a thought process, because I have realized one thing: courts have held 2 months delay, 1 month's delay to be too much of a delay. Now the film is almost on the horizon. But what about a script writer? He doesn't have a team of lawyers ready. He watches a trailer and he thinks, well, this is a script of mine. I had gone and told this producer this. And that equally for anything else, this delay part of it, if the court finds that the copyright infringement is blatant, if the court finds that the copyright infringement is something which is dishonest, then the court should, in my belief, stop that infringement at whatever stage. Today in Bombay High Court, you will be surprised, we have had just 1 or 2 instances where after a release of a movie also the courts have said, shut it down, I am not concerned. You cannot do anything further. Now in a recent case which I did, where there was a theatre in England being made on that movie Disco Dancer, and they tried to make it into a Broadway play. We went in the last minute. The court said, fine, they are delayed and all preparations are made. I'll let these 4 shows go on, but bring in every penny that you earn from these 4 shows into court. Now, once we have actions like that, if a person were to say that, you need to bring about some response to this advertisement, I feel that if your advertisement has generated this much, deposit an amount of this much in court, so that finally this other person is secured as damages. In our country, the only deterrent that works is money. And that fear is an illusion, because you know that when damages will get decided, by then it's all over. Half the time the plaintiff loses interest, particularly small copyright holders all lose interest. So therefore, that's where the crux lies, and we need harsh orders, we need very strict orders to bring about a decorum of enforcing copyright. And once that is done, then I think we'll be having a much more stricter regime where people themselves will also respect copyright much more. And I must tell, before I leave, all my producer and the entertainment industry friends here, that we as lawyers and judges have a very firm belief that whichever movies end up coming in court have not done too well. So please avoid that.
It's the other way around, actually.
No, in fact it's a historical thing which is very well spoken of. If you trace down the history of most of the movies which have come to court, this is of course in a lighter vein, it doesn't do well. So that's something which we should keep in mind and try to resolve these issues before court, because court can be always a very fluid, fragile situation. And therefore we need to protect our rights from day one, from the time we get a script prepared to everything. We are in an age where enough number of people just pop up from nowhere in the last minute, just in the hope that I'll make some money. So it's extremely important that from the moment we conceive a movie, we do everything within our means to protect every step of our thing, of how we get a script made, how money is paid. Everything should be well documented and well protected. That is the only way, I think, that we can safeguard a copyright litigation.
Thank you. I think you have a couple of more questions if you have time.
Yeah, sure.
Yeah.
Yes, sir.
Example that you quoted about a YouTube channel which kind of trains an aspiring actor on certain parts of or nuances about acting. Now, I come from the music industry, and it's been our endeavor to teach aspiring singers on the nuances of legendary singers of the yesteryears and about how they created music and what was it that made their music so special. So obviously this requires you to analyze the song, take it line by line, include all the parameters such as diction, expression, feel of the song, the raga, the framework and all of that. So when you pick up a song of a record label and you analyze it in detail and you were to coach an aspiring singer on those aspects, the question again comes up of the license and whether you can use, because the lyrics still remain the same, the rag framework still remains the same, though the coach may include parameters like innovation or you can always do a little bit more on the original work. You can add a few extra harkat or some things like that. But that apart, the structure of the song, the lyrics of the song, the main heart and soul of the raga still remains the same. So my question to you, sir, is that will that still come under the fair use? Because you are coaching a next generation, your wider scope is that you want to keep the legacy alive of the legendary singer and the yesteryear greats whom we are now talking about being a Bharat Ratna and all that. You want to keep the legacy alive. So can it be considered as a fair use and will it come under that is my question.
I'll tell you, sir, what you say is so right, and in my belief, what you do, it will depend on the manner in which you do it. According to me, and I believe that, depending on each case and how it unfolds, you don't even need to add to that existing song. It will depend on how you have analyzed it. Now suppose you take 2 lines of that song, you give it a pause, and thereafter what you want to do is you tell the students that just see here, see this part. You are then analyzing the song. Now suppose you show the full song, and after showing the full song, you just have a 30-second, 1-minute comment on it. Now there what happens is, the copyright holder feels that, see, I am showing this song on a paid channel. So instead of going there, people are listening the song here. Then he will feel aggrieved about it. But if you were to say break down that songs into paragraphs, or what you say antara, mukhra and all that, play that part, analyze it, then come to the next thing. It can never subserve or harm the commercial interests of the other person. In fact, to some extent, he might be very happy that you have raised his song to an level of an example. So he might be very happy with it. So it's ultimately your intent, how much you have used it, how the extent to which you have used it, and the manner in which you have used it. Ultimately, your intent matters the most.
Also part of his commercial activity, and you think he's drawing commercial interest out of that coaching?
Let's look at it this way. It is a commercial activity, but it's not a commercial activity competing with the commercial activity of that person. He is in a completely different commercial activity altogether. Now what prevents you, let's take it this way, of taking a book and just analyzing it? Don't you have critics of a book? Don't you have reviews of a book? Now what is he doing? He is basically doing something which would have been otherwise done in a classroom. Now does it stop anybody from taking a book which was released 20 days earlier, a professor asking each of them to read the book, and let's analyze it tomorrow, let's discuss it tomorrow? It's a part of that. So he is carrying out a commercial activity, but not a commercial activity which is in competition or affecting other person's commercial interest. That is the crux. It's not that every commercial activity harms.
I think we'll take one last question. Yes.
Hi.
My question is that increasingly when our students make films in their initial semester, they tend to use archival footage from news channels or other places. Does that come into serious? Because we had a lot of issues later when we approached the channels. They asking for money around 1,50,000, which is a zero budget exercise for us. And also when we make in the classrooms, we do analyze films and use clips, as you say. But if we make those into online classes, that becomes a copyright issue, right? Or does that come into fair use?
I believe that, as I told him, it's ultimately the extent to which you are showing it, the purpose for which you are showing it. Why would a teaching on the basis of anything, suppose you are teaching students of how to deliver a news on television, you are training somebody to be a newsreader as a part of your class, aren't you going to show him how newsreaders all over the world are talking? Without that, how will they be trained? So it's an essential part of the teaching, and the purpose is not to commercially capitalize on that news channel. Your purpose is to use that news channel for a purpose very different than a commercial use of that for a commercial purpose. You are the whole purpose of a fair use means you are using it fairly, something which is not in competition with him. So as long as that is so, and if you have a look at the Delhi High Court judgment, it gives very good guidelines. It says, how much is it a substantial use? Tell me something, don't we, when you write an article, take an extract from a book and quote from it?
Right.
You quote it, you give credit to that book. If you don't give credit to that book, it's a violation of copyright. But if you give credit to that book, then I don't see why it should be. Now, if you take an article and you just have an opening The remaining is 20 pages of an extract from a book, and you have a conclusion. Now that may be a copying, that may be an infringement of the copyright, but the extent to which you use it, the manner in which you use it, all that is relevant. And the example which you gave, if suppose you use a 20-second clipping or 15-second clipping from an archive of a news channel, and then analyze it in some way, or as a part of your article, if you could extract from a book as a part of an article and give credit to that, why can't you use that 10-15 second clip? I don't see any harm in that.
Thank you, sir. Thanks.
I think interesting takeaways, from Dr. Saraf. Thanks a lot for your time.
Thank you so much, and my apologies for leaving, because I just had thought it will get over by 10:30.
And I'm sure the college is going to soon invite you to give a more detailed lecture.
It's always these questions which leave us with a lot to think. Thank you so much.